By order of the court. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine Scale Form PC 586. This is the Petition and Order form. Scale for State Court Administrative Office, PC for Probate Court. Form 586 is a form that we'd be happy to give to you free of charge. Just contact our office. With all of these forms, these scale forms, they are created or given rise by virtue of various statutes and or court rules. And as you can see from the floating arrow, it's MCR 5.113. Now, this form is a generic form used in the probate context. And in probate practice, we call this motion or petition practice. You file a petition, you give notice, there's a hearing often, and then the court speaks through its order. So this is both a petition and an order, all contained in one form. So many times when you file a petition with the court, you are drafting from scratch the language within the petition. Or you can use this form if the information contained within it is a little more narrow or shorter. You can use the petition and order all within a pre-approved scale form. Now again, how to use this, when to use this, is really a bit of both experience and a little bit of an art form that lawyers who have been doing this for a long time know when it's appropriate to use a petition and order form versus drafting these pleadings from scratch. That's why when you're navigating through this probate process, whether it be a deceased estate, trust administration, guardianship, conservatorship, whatever it may be, we strongly urge you to be working with a skilled, competent, experienced probate practitioner who knows how to navigate through this process. It's not simple and it's not intuitive. It's actually quite confusing for people. And the language and the process is really something that a lawyer who's been doing this for a long time can navigate you in a much more effective way than trying to stumble through it on your own. So just the basic process of asking the court for something, that's done through a petition. And then when the court makes a ruling, that's done through an order. Let's work our way through this particular form and show you in its basic form how it works. The top left corner is the county in which the probate matter exists, and the top right corner is the case number or file number. In the top, in the matter of, it could be a deceased estate, it could be a guardianship, conservatorship, whatever the name or title of the particular matter upon which you're seeking the court's relief. The next section under 1 indicates your relationship to the particular matter. What are you asking? In what capacity are you asking the court to do something? So it says, I'm interested in this matter and make this petition as state relationship. Are you an heir? Are you the guardian? Are you the personal representative? Are you a creditor? What is your relationship to the matter that's referenced above? Section 2 identifies the interested parties' addresses as set forth in the initial petition or application that had been filed with the court. In most of the scale forms, they want this information for the person that's petitioning to constantly update the court as to the names and addresses of the interested persons to be assured that those people get appropriate notice through this process. And again, noticing is defined within the statute and court rules, and understanding how to give notice of a particular petition is a really important function. Failing to give appropriate notice can both be really frustrating because when you get to court, if you fail to give notice appropriately, you may have your matter adjourned or dismissed. And even more critically, if you fail to give notice to the appropriate party, your matter can be, you could be sanctioned or overturned if you haven't given notice appropriately. So it's really important to understand holistically all of the things that are going on within this particular form. Section 3 just simply states the facts. So what are you asking? Are you asking the court to do something? Well, state the basis for the background information that the court would need to know to evaluate whether the relief that you're seeking should be accepted. So here you state the relevant facts, and as you can see, there's no lines, but there's a little bit of space. And of course, you can attach additional addendum as well as additional pages to support the petition. Section 4 is what are you asking of the court? I request that the court enter an order, and then you'd identify exactly that which you're asking. And again, it's really important to understand that this form is not a form used when there's an appropriate other form to be used. So, for example, in a petition for guardianship, you wouldn't use this because there is a scale form called a petition for guardianship and an order appointing guardian. So you wouldn't use the form to replace that which already exists. This is kind of a catch-all form that can be used in very specific contexts when you're making a request of the court. Section below the request section, there is a declaration, and with all the scale forms, you're declaring under the penalties of perjury that you've examined the contents of the document and they're true to the best of your information, knowledge, and belief. So again, be very careful about your language because you're certifying under the penalties of perjury that the information is true and correct to the best of your information, knowledge, and belief. A section for the petitioner to fill out their information as well as sign and date, and for the attorney to also sign and put their relevant information if there's an attorney involved in the file. And then the below section here with the rectangle around the word order is the section where the court decides, is the petition above granted? Is it denied? Is it dismissed? Or is it granted in part? And then the court could specify the part. So again, not the easiest form to understand how to fill out. It's used in very specific context, often when you're making a request when there isn't already an existing form to do so, and you're not going to fill out a long form hand-drafted petition. You may want to use a petition and order form under this particular court rule. Now again, with all of these forms, as I've stated earlier, we strongly urge you to be working with a skilled, competent probate lawyer. Get the advice and wisdom and experience and training that they have to be able to guide you through your particular probate matter. At the Probate Pro, we are passionate about everything probate. If you have questions about this particular form or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.